Involvement with the criminal justice system is life-changing. It matters.
Having a justice system that works is a really important part of a democratic society.
I'm Penelope Gibbs, Director of Transform Justice.
I'm Rob Allen. I've worked in and around criminal justice all my career.
This is the Transform Justice podcast, throwing light on the criminal justice system.
Hearing from people who know.
It's about whether the system's fair
and what can be done to make it better.
Today we're discussing a topical issue, the highly charged dispute between the Lord Chancellor, Shabana Mahmood, and the Sentencing Council as to how defendants should be sentenced. Rob, my co-host, happens also to be an expert on the Sentencing Council. And with us to discuss this are David Shipley, a former prisoner and now journalist, and Sonya Ruparel, director of the charity Women in Prison. Rob, what on earth triggered this dispute?
This is basically about some new guidance on sentencing people to prison, specifically when courts should ask for a pre-sentence report from a probation officer. These are reports produced about people who have been convicted, which provide additional information about their circumstances, background, and so on, and helps the courts to sentence them appropriately. Currently, courts are supposed to get these reports if they would find it useful, but they can dispense with them if they think it's unnecessary. Now, what this guidance does is list categories of people who have been convicted for whom a report will normally be necessary. Who's on the list? Women, young adults, ethnic, religious, and cultural minorities, and a number of other groups who are suffering from particular issues, addiction, mental health problems, people who have been subject to domestic abuse and so on.
So does the guidance say that the judges have to ask for a pre-sentence report when the defendant is from one of these groups?
They don't have to. The phrase is that they will normally consider it necessary. But equally, people who are not on the list, they can also ask for reports on those. There's nothing at all to prevent them doing so.
So is it the case that if the person who's been convicted is, say, a woman of colour and a mother, the pre-sentence report might remind the judge that there is often racial disproportionality in sentencing and explain the impact a prison sentence could have on her children?
Yeah. But it's worth saying, of course, that at the end of the day, it's the judge or the magistrate who makes the decision, isn't it? This is about reports that then feed into a process. It's a judicial decision.
And we mentioned the Sentencing Council, which is the body that produced this guidance. What on earth is that?
Well, this is an independent body comprising a majority of judges and some other experts, set up about 15 years ago. The idea of it was to try and make sentencing more consistent. And the way the Sentencing Council tries to achieve that is usually by making guidelines on specific crimes. So how a court should set about sentencing somebody for theft or a sexual offence or robbery. What they have done as well is produce what they call overarching guidelines, and the one we're talking about today falls into that category. It's not about a specific offence, it's about the part of the process in which they make a decision whether to send somebody to prison or whether to make a community sentence.
Right, I get it. David, this bit of guidance has been consulted on and reviewed by members of Parliament and was about to be implemented virtually a week ago. Who lit the touch paper and why?
The Shadow Justice Secretary, Robert Jenrick, brought this up in the Commons, and he questioned the Lord Chancellor, Shabana Mahmood, on whether she endorsed what he called this sort of two-tier justice, which was going to be brought in by the new Sentencing Council guidelines. He was essentially saying that under this system, if you are a black woman, you would have a better chance of avoiding prison than a white man, all other things being equal in your offence.
And was he right?
It's a bit complicated. So there's not a huge amount of evidence about the impact of pre-sentence reports. Certainly if you look at the communication and commentary from the Sentencing Council, they say that they've identified imbalances in the justice system, and they believe part of their job is to essentially put their hand on the scales a bit to rebalance that.
So Robert Jenrick's contention was that if somebody gets one of these pre-sentence reports, or one is done about them, that the judge was going to be more lenient.
I think his contention was that it would make the judge less likely to choose a custodial sentence. And I think it's worth saying at this point, I think pre-sentence reports are great. If someone is a mother, typically, who is caring for young children at home, we absolutely should consider that when we're deciding whether to send her to prison or not. Equally, if there's evidence that someone's been coerced into crime or is in some kind of controlling relationship, it's good that the judge has that information. I think the concern that Jenrick had, and then the Lord Chancellor echoed, was that this would not be applied evenly and fairly to all people awaiting sentencing.
OK, Sonya, what do you think? Do you think Mr Jenrick was right in thinking that this somehow promoted two-tier justice as far as racial, religious, cultural minorities are concerned?
No, I think he wasn't right. I think that it's trying to redress an imbalance, as David's already talked about. What we know is there's massive disproportionality already embedded in the system. So we know that if you're a black woman, you're twice as likely to be arrested than if you're a white woman. We know that 9% of the prison population is black, whereas the general population is only 4%. So we know that there's disproportionality already. And these guidelines, in our view, which we very much welcomed at Women in Prison, was to try to redress some of that imbalance and that racism that exists in the system. The Lamy Review in 2017 talked about racial bias in the system. There's a lot of evidence. So I fear that it's not an evidence-based argument. It feels a political argument. What's worrying is if you bring in this kind of narrative about a two-tier system where we all know that women are harshly judged within the criminal justice system. The government has admitted the majority should not be in prison. Our deep worry and concern is that women will be affected by these decisions that are being taken at the moment about this legal challenge.
I mean, David, the Lord Chancellor, is a Muslim woman of Pakistani heritage. Why do you think she joined Jenrick in criticising these councils? It's slightly surprising to me.
Yeah, I think since this story has happened, quite a lot of people have made statements in public talking about this idea that Shabana has sort of been conned or tricked by Jenrick, or that she's given in because of the politics. I don't think that's true. What I understand from talking to people close to her is that this is absolutely heartfelt for her. She thinks these rules are wrong in principle, and she also thinks that the way in which they have been produced and the way in which the Sentencing Council has, as she sees it, sought to expand its power is wrong as well. So I don't think this is her playing politics. And she wrote a really good letter to Lord Justice William Davis, who's the chair of the Sentencing Council, in which she says that she perceives the idea that people would start to believe there is a two-tier justice system as being a direct threat to women of colour, for example. And I think she's right. I think if we get to a situation where the majority community in this country start to believe the justice system is biased against them, then we are in the realm of politics, and not nice politics.
Sonya, were you surprised of the kind of things she said about the race element of this dispute?
Yeah, I was surprised, actually. And I'm hearing she feels very strongly about it. But I also hear that she feels very, very strongly about women and how they're treated within the criminal justice system. And for me, it just doesn't quite tally. We're in danger of making the same argument about different things and it kind of coming out all the worse for women rather than better.
You had some guidance which said that women should get pre-sentence reports, particularly women who are pregnant or who had children who they cared for. What's going to happen to that?
Yeah, so that's a real concern, as the Chancellor is trying to change the law so that those guidelines don't go through. And I'm a bit unclear as to whether she's going to want to remove all of those cohorts, which is a really risky thing for women. And it's not just those who are pregnant, which, you've talked about very clearly, they should not be imprisoned, but also those experiencing domestic violence and abuse, which is practically 60% of women in prison. So women will be very, very affected, I think, if these guidelines don't go through.
Part of the problem here is the sort of bundling of characteristics. I think almost no one disagrees with the idea that we shouldn't be jailing pregnant women. It's astonishingly unsafe for women and children. In fact, most women, I think, in prison probably don't need to be there if you look at the kinds of crimes they're jailed for and the relative lack of risk they pose to the public. But because this has all been bundled together, unfortunately, these changes for women, and particularly pregnant women, have been sacrificed by the way that the Sentencing Council has approached this.
So Sonya, in her Labour conference speech, she said, the law has taken too long to address the realities of women's lives. Written mostly by men, the male experience is its default setting.
Yeah, which is all very true. I suppose also the guidelines are not policy or legislation. They're guidelines, and they're one methodology of trying to redress some of these imbalances. There are other ways perhaps she could look at to try and redress those imbalances, but I think very deliberately removing this from the sentencing guidelines may well affect women.
Has she sacrificed women?
I would say there's a real potential of that. We don't know yet what the legislation will do.
So, Rob, what does the legislation seem to do? So this is the legislation that has been tabled to kind of undo what the Sentencing Council has put forward.
Well, it specifically prohibits a guideline from listing things like racial minorities, cultural minorities, religious minorities as categories for whom pre-sentence reports should normally be provided. So it tackles head-on this issue about what Shabana Mahmood describes as differential treatment. It then, in the explanatory notes to this legislation, says, but this is not an exhaustive list. So could women be included in a sentencing guideline? Could young adults? The logic, it seems to me, is that there's no place for this presumption, if you like, that there should be a pre-sentence report for these groups either. But it's not very clear, and the legislation hasn't yet properly been debated, and it's possible that there will be some changes or some clarification, at least, before it does become law. But the whole thing is very, very messy, it seems to me.
I mean, David, if the legislation goes ahead and it's clear that race, faith and cultural background are included, as in those factors cannot be taken account of when considering whether to produce a pre-sentence report, but women are specifically excluded, we're going to be in an odd place, aren't we?
Yeah, it's very hard to see how that would be a logically or internally consistent position to hold. I don't see how you could argue that it's wrong to prioritise certain ethnicities or religious groups, but right to prioritise women in a way that would be consistent or politically saleable.
David, you've written in one of your articles in The Spectator quite critically about the way the Sentencing Council has sort of engaged with the Lord Chancellor and communicated with her. What didn't you like about the way they did that?
Lots of things. So Davis wrote a couple of letters to the Lord Chancellor, and they're astonishing reading. First of all, they're very long. And a lot of the time what he likes to do is explain in detail that the Sentencing Council has followed procedure and that therefore their conclusions must be correct, which I think is a very naive attitude to take, because in reality, when the politics shift, the ground shifts and you have to move with it. You can't just say, well, we follow procedure. His tone is, I think, at times quite dismissive as well of the Lord Chancellor's office and of her person. And I think that was shocking to me, because I think it's, first of all, quite rude if you read parts of it, but also really bad politics. I don't think Davis realised the game he was playing. In his first letter, he essentially said it's none of your business and it would be wrong for you to even think that you could direct sentencing guidelines. And he doubled down on that in the second letter.
But didn't he have a point in the sense that, in effect, this is a judicial body? It's a majority of judges. Before it was set up, there was a working party that was discussed what it should look like, and it was very clear that it needed to retain some independence in order for judges to take a blind bit of notice of what it was saying. So isn't there an issue about the judges wanting to be seen to maintain their independence? Otherwise, the council simply wouldn't work.
Yes, of course, we should have an independent judiciary. We would never want to have politicians telling judges what to do in a particular case. That, I think, would be absolutely wrong. But the idea that the sentences for different crimes can't be or shouldn't be determined by Parliament seems to me very strange. I mean, Parliament writes law to define what is a crime, and it will, in that law, define sentencing. So it's very properly the business of Parliament and I think of ministers to have a view on whether sentencing is okay. And I think there's a real issue here that the judiciary has to remember that they do require consent both of the popular will and of politicians, because ultimately they are a tool of the state, not able to direct the state. I do think the goal of a lot of these guidelines was really positive, and I think it's really sensible. But I think the approach the Sentencing Council have taken is very blind to political reality, which is that, people want to have a say in how crimes are punished. And I don't think that's an unreasonable preference for people to have or for politicians to seek to implement.
Sonya, what do you think? Do you think that ministers should be entirely over the detail of sentencing in its technicalities?
No, I mean, I read it all slightly differently, actually, because I felt the letter was really helpful because it really did outline a very, very long and detailed consultation process where everyone was invited to give their views and thoughts. And then the outcome was really based on the consultation, the facts and the evidence. So I thought it was incredibly helpful to read that and be really clear about where it has come from. So I think then if you kind of dismiss all of that consultation and say ministers need to take these decisions, I think you're undermining the whole kind of purpose of that very democratic process that was put into place.
Can I just come back to David? So there is some evidence, at least, that for some crimes, black and brown people get harsher sentences than do white. And what the Sentencing Council is trying to do here is, as you said, to try and, if you like, correct that imbalance. Now, from your point of view, is that wrong of them to want to do that, given that one of their objectives is to promote confidence in the system? You've said that what they might be doing might reduce the confidence of some people, but we know that confidence in the criminal justice system from black and minority people is very much lower. Surely they are duty-bound to try and do something to reduce those so-called disparities.
Yeah, I think, as you said, there is definitely some reasonably strong evidence that those disparities exist. We do need to address the fact that in many ways the justice system as a whole is racist and classist. I don't think it's the business of the Sentencing Council, though. The Lord Chancellor has also said this, that her view is that actually it's a matter for ministers and Parliament. And I think that's true. I mean, first of all, philosophically, it is right that these big decisions about how we run our justice system are determined in a truly democratic way. But also, I think, sort of strategically, if you desire justice reform, what this whole affair has revealed is the huge risks inherent in trying to achieve reform through these arm's-length expert bodies without winning popular support for it. A campaign which would be able to be successful in the long term would actually rely on convincing the public that these disparities exist, communicating about that, and talking about what we need to do to make the system fairer. And I think that's a really good argument which actually could be made to win people over. And trying to shortcut it or avoid it by going down these expert body or quango routes, I just think makes no strategic sense, as we've seen here.
Sonya, do you think that, Shabana and Robert Jenrick were opposing this guidance because they felt it would be unpopular?
Yes, I suspect that is true. And I'm really interested in this kind of, you need to get the public opinion on board. Most people, I think, do accept that there are racial disparities within the criminal justice system.
I think if you ask most people on the street, they would not echo that. And I suspect that's why this issue has been so toxic, because people believe that the system is fair and the Sentencing Council is now going to favour certain groups.
But I mean, there is a good deal of evidence, not just at sentencing, but all the way through. I mean, David Lammy produced a catalogue of evidence about the outcomes for black and minority ethnic people being worse in the justice system. I think it was widely accepted that he was right. And as a result of that, a whole range of organisations, the police, prosecutors, and the Sentencing Council up to a point, have been encouraged and have taken some action to try and redress that. Isn't that really what this is about? That until very recently there was an acceptance of poor outcomes that needed to be reversed, and then for whatever reason the wind has changed, and arguably that is because we have a more powerful right-wing conservative view represented in some political parties and so on, and that has added some kind of pressure to the debate that wasn't there before. Is that the right analysis, do you think?
I don't think so, no. I think absolutely expert bodies and organisations and public bodies accepted many of the findings of the Lammy report and decided they would start to address those. Would the average member of the electorate be familiar with the Lamia report? Would they agree with its findings? I don't think so. We have just had an election in which a Labour government's won a vast majority. We're not living in a reform Tory government. And I think the tension here is between public bodies which are seeking admirable goals but are trying to do it by using the administrative state, not the democratic legislative state. And I think what we're seeing is what happens when the distance between the two becomes too great, and when actually the general preferences of the electorate, and therefore by extension politicians, become too distant from the administrative state's choices, then politicians, because they like being elected, will act to rein the administrative state in.
So, Sonya, what do you think? Do you think it's that, or do you think it's fear of reform? I mean, fear of the power of the Reform Party under Nigel Farage?
Yeah, I mean, I suspect that plays into it. I just want to just kind of come back on this. Whose responsibility is it to address racial injustice? Fundamentally, every public body has a responsibility under the Equality Act to address discrimination when they see it. So it's not just a political thing. If we don't address it at every stage and in every part of an arena where we have some authority and legitimacy to do so, then we're going to fail to bring in equality. So I think it is their responsibility, actually, to do so.
I don't necessarily disagree with you. I think what I'm saying is that you also need to bring the electorate with you. If that gap becomes too wide, and if the work hasn't been done to sell, to persuade, to convince, then we run into these issues where politicians grab back control and we can lose what would otherwise be very sensible advances.
I suppose my question here is, because it's a sentencing guide, I wonder how much the electorate even understand what this even means. And it's blown up into a political debate that suddenly does involve the electorate, where it needn't have done. Potentially, I think if it had been managed slightly differently in Parliament, then this wouldn't be an electoral debate of concern, but it's the Sentencing Council doing their job. This is such a technical area of justice.
Whether somebody and who gets a report in advance of sentencing. Yeah.
Exactly. That is mostly invisible to the electorate. So to get into that level of technicality where the electorate need to have a kind of a strong view on that, and there's been a consultation of the experts within that space who have the evidence and facts to be able to feed into it, it feels slightly disproportionate.
I don't think it's that complicated, right? I agree they probably hadn't thought about it before 3 or 4 weeks ago because, frankly, as we've seen, even most ministers and politicians hadn't thought about the Sentencing Council guidelines until 3 or 4 weeks ago. But the fact that something has been done without people paying attention to it doesn't necessarily mean it's illegitimate for the public to show interest or for politicians to. And actually, Davis made a point similar to yours in one of his letters where he said that when we issued the consultation document a year ago, there was no press interest and no politicians seemed to care. And it's like, well, that is true. There was probably other stuff going on. But I think it's perfectly reasonable for politicians and for the public to care about the administration of justice. And actually, I think we should encourage people to be interested in the boring technical administration of justice, because ultimately, if we want to have a justice system which is fair and which is free of racism and other forms of discrimination, we have to get the electorate to care about it and to get them on board.
I mean, I agree with that. I would challenge you in any idea that the electorate are even now that interested in this guidance. I think the politicians were interested in this guidance. The media love a spat, so they got fascinated by the spat and a bit about the guidance. I've personally seen no evidence that the electorate are that interested in this guidance.
I think that's probably true of every justice story, right? But I think each time these stories come up, it's a chance to talk about things and to slightly raise awareness. If we can use the attention of a spat, of a story, of a fight between a Quango and a minister to actually inform people and raise their knowledge, I think that's a good thing.
If that's true, that we need a kind of a proper debate, an electoral debate, and we need more views on it, the government pushing through legislation very, very quickly, that's not going to solve that. That's the government then taking a decision without that proper debate to stop this from going through. So it feels like it doesn't quite sit right then.
Yeah, absolutely. I think the legislation became inevitable once Davis said that he wouldn't back down and that the rules were coming in. At that point, the Lord Chancellor either had to surrender to him, in which case her authority would have been shot, or she had to do something. And ultimately, the tool she had was legislation to stop it happening. What's going to be interesting is when the more substantive legislation comes in that's going to change the role of the Sentencing Council. I think that's where I hope, will see a really solid debate in Parliament about what sentencing should look like, what should be determined at the expert level what should be set in terms of guidelines by Parliament. But yeah, this emergency legislation is not that.
So just to set it out, what happened in this whole debate is that the Sentencing Council did dig their heels in on this. And to be honest, if they had conceded at some point, there would be no emergency legislation. Rob, I mean, you've written for us, for Transform Justice, ironically, about the reform of the Sentencing Council and how you think it should be reformed. But your criticism of the Sentencing Council is a very different one, isn't it?
Yeah, it is. Our criticism has generally been that they haven't done enough to reduce the use of imprisonment and to reduce the length of prison sentences.
And other sentences.
Yeah, and we think they should have and could have done more. I mean, ironically, from my point of view, this guideline that has caused this huge row is probably the best that they have produced, because it does seriously address the issue about people who are what is called at the cusp. They could get a prison sentence or they could be sentenced in the community. The importance of certain things being taken into account by courts. These are all really positive, it seems to me, which is why it's such a shame. And many people who've campaigned long and hard, like Sonya, on women, people on mental health, addiction, issues like that, are so disappointed that at the moment, to our minds, a positive guideline is sort of in abeyance pending some resolution of the row.
Sonya, I mean, obviously you're concerned about this legislation and the effect it might have in terms of particularly women. What about the rest of the system? If you crawl through, there are so many bodies, some of which are much nearer to government, who have policies which are trying to address the discrimination that some groups face and have guidance, which is not a million miles from this. Do you think it's at risk? All the other policies attempting to prevent discrimination?
Yeah, I do. I'm particularly worried about the sentencing review that is ongoing, that's being led by David Gauke. What we're hoping for is that they would abolish short sentences. Mostly they have been discredited, and so many women are in prison for short sentences. They don't rehabilitate and they go on to often reoffend. So they have been broadly discredited, and we want to see an end to that. But I am concerned that the politics playing into all of this kind of narrative might affect the outcome of what comes from that sentencing review, which is obviously being commissioned by the Lord Chancellor.
Yeah, it's an interesting one, isn't it? Because it's a, in quotes, independent review, but it also, in its agenda of what they're supposed to be looking at, did say that they should be looking at particularly, how women are treated and so on. So in a way, Shabana has outsourced a bit of policymaking.
It's probably more the case that they have a view on policy, and that having a former Tory Justice Secretary conduct this review creates some political cover for what they want to do, because they can present it as independent or quasi-independent and cross-party. I'm maybe more optimistic than you are about the guidelines we're going to get, because I think the conditions in the prison system, the lack of capacity, mean that they have to move on this stuff. So I think short sentences are going to go. We're going to see something like the Texas system where you can earn earlier release. I think my big concern around how that will interact with discrimination in the system is actually the way you earn early release is going to be by officers in prisons on the wings giving you good behaviour points. And what that actually means is prisoners who present in a certain way and communicate in a certain way and look a certain way will get out quickly, and prisoners who are discriminated against because of neurodivergence, because of race, because of cultural differences, because of language barriers, will spend their whole sentences in prison. I think that's my big fear. The actual execution on the ground is going to be really bad, because prisons are an especially racist part of the justice system.
Yeah, I'll just add to that. I agree with that wholeheartedly. I think one of the fears, of course, is if they abolish short sentences, so many women go into prison because of underlying structural reasons, domestic abuse and mental ill health. And if they don't then increase the kind of support in the community, then they will be let down and potentially back in the system. So it does need to come with some kind of work to challenge the potential discrimination and to support people in communities themselves.
Okay, well, thanks. We need to draw this fascinating discussion to a close. Can we finish by asking you each a question? The Lord Chancellor has said during the course of this dispute, she wants to ensure that all stand equal before the law. If you were Lord Chancellor, David, what one thing would you do to achieve that?
So we don't have really good data on this. I would commission a study in which we look at every single person who is arrested, charged and sentenced for a whole year. And we would look to capture this data around race, around culture, around sex, around neurodivergence, around life backgrounds, and actually try to prove where the discrimination is happening and why.
OK. Sonya, what about you?
I would try to look at, beyond the kind of basic data, look at the root causes of why people end up in the justice system in the first place and take that into consideration every single time.
OK. Penelope?
I've got a slightly left field one here, which is that I would ensure that everyone who was at risk of imprisonment or in the criminal justice system had really high quality, free legal advice. I actually think it makes a huge difference to how they're treated. And Rob, what about you?
Well, I would say to myself that I don't think treating everybody equally before the law necessarily means treating everybody in exactly the same way at every stage in the process. In terms of the specific issue, I would amend the law to say that nobody can be sentenced to imprisonment under 2 years without an up-to-date pre-sentence report being prepared.
Great. Thanks all. And if you would like to find out more about the Sentencing Council and read what our contributors have written about the row or their organisations, do look at our programme notes. Till next time, goodbye.
Goodbye.
Bye.
Goodbye.